Okay, I'm going to briefly speak about the consequences of the non-ratification of the EU-Colombia Peru trade agreement by one member state, by one EU member state. And I'm going to speak about this in three steps. I'll first look on the general public international law issues on the entry into force of agreements, specifically of this agreement. Then I'll speak a little bit about the issue of mixed agreements. And then finally, I comment on some aspects of provisional application in the context or in the situation of a non-ratification. Now, to start, the EU-Colombia Peru trade agreement is an international agreement under public international law, and therefore its entry into force is determined by the rules of public international law on international agreements. And in this respect, the rules are contained in the Vienna Convention and the law of treaties, and they basically provide that an agreement enters only into force after all parties have formally consented to the treaty. And that can be confirmed by a closer look into the provisions of the EU-Colombia Peru trade agreement. And in particular, I'm referring here to Article 330 of the agreement, which contains the conditions for the entry into force of that agreement. Accordingly, each party to the agreement shall notify the completion of its internal procedures required for the entry into force of the agreement to all other parties and to the depositary. So basically, after each party has concluded its internal procedures for ratification, it shall notify the other parties and the depositary. Subsequently, this is Article 330, paragraph 2, the agreement will enter into force between the EU party and each signatory Andean country on the first day of the month following the date of the receipt by the depositary of the last notification. So we can therefore basically conclude that in order to enter into force of the agreement, all notifications of ratification are required. The term EU party is defined in Article 6, number 1 of the agreement to mean the European Union or its member states, or the European Union and its member states within their respective areas of competence. So therefore, for the purposes of Article 330, the EU party is the EU and its member states. Consequently, the agreement enters into force after the ratification of the EU and all member states on the one side and Peru and Colombia on the other side. The agreement does not foresee the possibility of entry into force only between certain consenting parties. All parties have to consent. I'm coming now to the special situation of mixed agreements. International agreements concluded by the EU and its member states jointly, which are called mixed agreements, cannot be split into different parts depending on the internal distribution of powers between the EU and its member states. So the agreement cannot be divided into a trade part and a non-trade part. The general purpose of mixed agreements is to disregard the division of competences between the EU and its members, which is usually not known to the partners of the EU and sometimes not even known to the EU and its member states themselves. So generally, international agreements which are negotiated and agreed upon as an integral whole cannot be divided into different parts without reopening the negotiating process. These rules, or this is also confirmed in the rules on the Vienna Convention on the Law of Treaties. So therefore, if one party does not ratify the agreement, it cannot enter into force as a whole. Now, thirdly, in particular in the context of the debates on the ratification of the EU-Colombia Peru trade agreement in certain member states, such as Germany and, if I'm informed correctly, also the Netherlands, it has been argued that in the case of non-ratification by one EU member state, the trade part of the agreement could be implemented anyway, because the EU has the exclusive power in trade matters, whereas other parts of the agreement, which led to its characterization, in particular the provisions on human rights, would then not be implemented. Now this view, in order to assess this view, different scenarios need to be distinguished. The argument could refer to the possibility that the EU could renegotiate the agreement and conclude a trade agreement which is a trade-only agreement. And then, of course, because the EU has the exclusive power on trade matters, it could conclude that agreement without the consent of the member states. In this case, the provisions on human rights and disarmament and non-proliferation of weapons of mass destruction would have to be deleted, and possibly also some other provisions. That would, and this is important, be a new agreement that would be renegotiated between the EU and Peru and Colombia. Such an agreement would then, of course, also require the new consent of the European Parliament, which, again, seems unlikely because it was, of course, the European Parliament, or parts of the European Parliament at least, which demanded particular provisions on human rights. So I think renegotiation is renegotiation as a trade-only agreement is not an option. Alternatively, the view could refer to the possibilities that the parties to the agreement opt to implement those parts of the agreement which are within the EU competence provisionally. This is possible on the basis of Article 330, paragraph 3 of the agreement. That holds that the parties may provisionally apply this agreement fully or partially. The provisional application requires, however, the consent of all parties. That means also the member state which has rejected the ratification would have to consent to the provisional application. It is possible that, depending on the constitutional situation in the member state concerned, the decision on the provisional application could be taken by the government only, without parliamentary consent. However, it's important to realize that in international practice, an agreement is usually provisionally applied pending the full entry into force because the ratification process in one or more countries is delayed. Such delay may sometimes last for quite a long time. Actually, in the GATT, we had a delay, so to speak, theoretical delay of some 40 years. But it is highly questionable if the provisional application is possible after the final non-ratification of the agreement by one member or by one party. The term provisional, such as in Article 330, paragraph 2, indicates that it is a rule for a situation which is not final. However, a decision not to ratify an agreement is a final decision from the perspective of the relevant member states. In other words, a provisional application requires a, in quotation mark, pending state of affairs, not a definite one. Only very special circumstances may justify a different approach. For example, the government of the member state who initially rejected the ratification could indicate to the other parties that it intends to seek ratification again at a later stage, maybe after an election or maybe after certain other political events. In this case, one could argue theoretically that the situation is still pending and a provisional application could be possible. However, as far as I know, that has never happened in international practice, and if it would happen, it would have to be very special and very rare cases. Normally, international practice suggests that the non-ratification of an agreement which requires the consent of all parties to enter into force puts an end to the agreement. So as a consequence, if one EU member state does not ratify the EU-Colombia Peru trade agreement, it will not enter into force, and it will most likely not be applied provisionally. Instead, the agreement would have to be renegotiated. Thank you very much.